Hello friends, welcome to Prashant IAS. So friends, in the last class, we have completed fundamental rights. And from this class, we will start our discussion with the types of writs. So friends, let's begin. So the first type of writ is Habeas Corpus. Now friends, what is the meaning of Habeas Corpus? So the meaning of Habeas Corpus is to have the body. Okay, so what is the meaning of habeas corpus? The meaning of habeas corpus is to have the body or to obtain the body. Now friends, the question arises that when this writ is issued by the court. Okay, so what is the question? That when is this writ issued by the court? So the answer is that when an individual is detained without any legal justification or is missing, then the writ of habeas corpus is issued by the court asking for the person to be brought before the court. Now what does it mean? So I will give you one example so that you can understand this concept. So friends, suppose there is a person and the name of that person is Pappu. Now friends, suppose first condition. Okay, so here we will imagine two conditions. So in first condition what happened? That police arrested the Pappu. So in first condition what happened? That police has arrested the Pappu. And friends, police has arrested the Pappu illegally. Okay, now what does it mean when I say that police has arrested the Pappu illegally? So it means that, for example, police has not told the ground of arrest when police was arresting Pappu. So first of all, police didn't tell the ground of arrest. Okay, secondly, police didn't have any proof when police arrested Pappu. The third thing is that police didn't allow the Pappu to contact his family members or to inform his family members that he is being arrested by the police. The fourth thing is that police didn't presented the Pappu before the magistrate. Okay, so the first condition is that police arrested the Pappu illegally. Now let's imagine the second condition. The second condition is that somebody has kidnapped the Pappu, okay, or Pappu is missing. Okay, so somebody means any private individual or any private organization has kidnapped the Pappu or Pappu is missing. So this is second condition. Now friends, in both the conditions, definitely Pappu is missing from the home because family members don't know that whether the Pappu is arrested by the police or somebody else has kidnapped the Pappu. So what the family members of Pappu will do? Now the family members of Pappu, the parents of Pappu or any other relative of Pappu, they can directly approach the Supreme Court and they can file a writ petition under habeas corpus. Okay, means in simple words, they can simply file a case in the Supreme Court and they can claim relief from the Supreme Court. Now friends, in these conditions, what Supreme Court will do? So in first condition, when Pappu was arrested by the police illegally, in that condition, now what Supreme Court will do? That Supreme Court will issue order. So now what Supreme Court will do? Supreme Court will issue the writ of habeas corpus. Now what does it mean? It means that Supreme Court will give order to police to present, to bring Pappu before the court. Okay, so what is the meaning of habeas corpus here? So the meaning of habeas corpus is that Supreme Court will give order to police that it is the order that bring Pappu before me. Means what is habeas corpus? Habeas corpus means to have the body, to present the person with his body before the court. So what court has done? Court has ordered the police that bring Pappu before me. So in this case, what police will do? Definitely now police has to follow the orders of Supreme Court. Otherwise, Supreme Court can take action against police also. So now police will present the Pappu before Supreme Court and definitely when Supreme Court will find that police arrested Pappu illegally, so in that case, Supreme Court will release the Pappu. Okay, and definitely the personal liberty of Pappu is restored. Now let's imagine the second condition. So what happened in second condition? That Pappu was kidnapped by any other private individual or he was missing. So now in that case, what Supreme Court will do? That Supreme Court will order the government or the police to bring Pappu before the court. Okay, now what Supreme Court will order? Supreme Court will order the police or the government to bring Pappu before the court. But now, friends, Pappu is not with the police because Pappu is kidnapped by any other person. So now what police will do? Definitely police will conduct the investigation. Police will search for Pappu, and after finding the Pappu, police will present Pappu before the court. Okay, so in this way, the writ of habeas corpus protects the personal liberty of a person. Okay, so if any person is detained illegally by the police, or if any person is kidnapped or missing, then court can issue the order of habeas corpus, and court can order the police and the government to bring that person before the court. So this was the meaning of habeas corpus. Now friends, it is also known as the great writ. So why it is also known as great writ? Definitely because it gives us protection against the illegal arrest of police, and definitely it gives us protection against the kidnapping. So it is a great writ. Why? Because it actually gives us protection against the it definitely gives us protection for our personal liberty. Means police cannot arrest us illegally. Now friends, this writ can be issued against, the first is state functionaries and second is private individuals and organizations. So what does it mean? So state functionaries means government, okay, police, okay, so these kind of organs means government organs. So court can issue this writ against government and other government organs, and court can also issue this writ against private individuals and private organizations. For example, in our example, in first condition, court issued the writ against the police. And what is a police? Police is a state functionary. And in the second condition, court issued the writ against any private individual who kidnapped the Pappu. Okay, so this writ can be issued against state functionaries, means government organs, as well as private individual and private organizations. Now friends, then the next question arises that who can file this writ in the court? Okay, so who has the power, who has the authority to file this writ in the court? So let's discuss the answer. So this writ can be filed before court by an individual or organization and not necessarily only by the aggrieved. Okay, so what does it mean? It means that any person or any other organization can file this writ in the court on behalf of any other person. What does it mean? It means that it is not necessary that aggrieved person should file this writ in the court. Okay. For example, when I gave you the example of Pappu, so in first condition what happened, that Pappu was arrested illegally by the police, and in second condition Pappu was kidnapped or he was missing. Okay. So what happened in both of these conditions? What happened, that the parents or any other relative of Pappu filed the writ petition in the Supreme Court. Okay, so Pappu himself didn't file the writ petition. Who filed the writ petition? The family members or the relatives of Pappu filed the writ petition. So it means that it is not a must that the person who is directly affected, he has to file the writ petition. Any other person or any other organization can also file writ petition in the court on behalf of the affected person, means on behalf of the aggrieved. For example, in our example, what happened, that Pappu himself didn't find the writ petition. Who filed the writ petition on behalf of Pappu? The parents of Pappu filed the writ petition on behalf of Pappu. Thus friends, the principle of locus standi does not apply here. Okay, so what happens, that the principle of locus standi does not apply here. So what is the principle of locus standi? Okay, so now question arises that what is the principle of locus standi? So principle of locus standi is the right of a person to go to court and get his rights implemented. Now what does it mean? So it means that suppose if any fundamental right of any person is violated, then that person himself has to go to Supreme Court and that person will get his right implemented. Okay, so in the simple words we can say that local standi means if the fundamental right of any person is if the right or any fundamental right of any person is violated, then that person himself has to go to court. Okay, and then court will give him relief. For example friends, suppose we all know that under Article 17 we have the right against untouchability. Okay, Now suppose if any person has practiced untouchability with you, means any person is trying to practice untouchability with you, he is trying to declare you untouchable. Okay, so in that case we know that he violated your fundamental right. So now it is your duty to go to court. Okay, so now you will go to court and you will file a case against that person. Okay, and then court will give you relief. Okay, so if your fundamental right is violated, then you have to go to court. Okay, so if a person's fundamental right is violated, then that person himself has to go to court, means any other person cannot go to court on behalf of him. He himself has to go to court for getting his fundamental right implemented. Now friends, the question arises that why does the principle of locus standi not apply here? Okay, so now we know what is principle of locus standi. We also know that in the case of habeas corpus, the principle of locus standi does not apply. So the question arises that why does the principle of locus standi does not apply here? So friends, here since the person is behind the bars or missing, he himself cannot go to court, and thus locus standi does not apply here. Now what does it mean? It means that the aggrieved person, means the affected person, is either he is arrested by the police, so he is behind the bars, or he is kidnapped. Means what does it mean? It means that the person is not free. Either he is kidnapped, either he is missing, or he is behind the bars. So definitely it is a common sense that person himself cannot go to court. Why? Because he is not free to go to court. So definitely, so if person cannot go to court, so any other person, okay, any other person, his relative, his family member, or any acquainted person, so any other person or any other organization can go to court on behalf of him. Okay, and they can file habeas corpus on behalf of him. For example, here we take the example of Pappu. So what happened in first condition, that Pappu was illegally arrested by the police. So Pappu was under the control of police. Pappu was behind the bars, means Pappu was in jail. So definitely if a person is in jail, he cannot go to court. Okay, because he is under the control of police. He is under the detention of police. So definitely if Pappu was not allowed to go to court, then who will go to court? Definitely his family members will go to court on his behalf. So what happened in our example, that the parents of Pappu go to court, and parents of Pappu filed the petition of habeas corpus in the court. Okay, and then court ordered police to present the Pappu before the court. Okay, so that's why the locus standi does not apply here. So friends, now let's move to another writ. So then comes Mandamus. Now question arises that what is the meaning of Mandamus? Means what is the meaning of this writ? So friends, this writ is issued in the nature of command by judiciary against the public authority or a person holding public office. Okay, so what is the meaning of Mandamus? So the literal meaning of Mandamus is that we give the command. So Mandamus means command. Okay, so the Mandamus is issued in the nature of command by judiciary against a public authority or a person holding a public office. Okay, now what does it mean? So friends, suppose if there is a government officer and that government officer is not doing his work properly. Okay, means he is not doing his work, and due to that people are facing problem. So now Supreme Court can issue the writ of Mandamus. So Mandamus means Supreme Court is giving order, Supreme Court is giving command. Okay, so Supreme Court is giving command to that government officer. So now Supreme Court can issue the writ of Mandamus, and Supreme Court can give order to that government officer to do his work properly. Okay, so Supreme Court by issuing the writ of Mandamus can force that government officer to do his work properly, so that people do not face the problem. Now friends, then the question comes that what is the purpose of issuing Mandamus? Okay, so what is the very purpose behind issuing the writ of Mandamus? So the purpose of Mandamus is to command a public authority or a public officer to do or not do certain acts in the nature of public duty. Okay, so what is the purpose? So the purpose is to command a public authority or officer to do or not do certain acts in the nature of public duty. Now what does it mean? So friends, I will give you one example so that you can understand this concept more clearly. Now suppose there is a person named as Bhadru. Okay. Now this person is having a house in a city. Okay. And we know that the affairs of city, they are generally managed by the municipality. Now friends, the house is constructed totally legally. Okay, means house is not illegal. But the municipality officers are claiming that the house is illegal. Okay, so what municipality is claiming that the house is illegal and municipality wants to destroy the house. Okay, they wants to destroy the house. Okay, the reason can be any. It can be any personal enmity. Okay, so municipality wants to destroy the house. Okay, and municipality is claiming that the house of Bhadru is illegally built. But actually, the fact was that Bhadru built his house legally, means his house was totally legally constructed. Okay, now friends, as we all know that, right, what is house? House is your shelter. And I have taught you in the previous classes that right to shelter is right to life. Means if you are not having a shelter, then your life is under threat. Okay, so nobody can destroy your shelter like this. Okay, so until you have constructed your house legally, then nobody can destroy your house. Okay, but municipality was claiming that house is illegal, and on that ground municipality wanted to destroy the house. But now what Bhadru did, Bhadru filed a case in the Supreme Court that they are actually snatching my right to shelter, and right to shelter is right to life. So municipality wants to snatch right to life from me. So now what Supreme Court will do? Supreme Court will definitely examine the case. Supreme Court will review the action of municipality. Okay, and friends, when Supreme Court examined the case, what Supreme Court find that the house of Bhadru was totally legal. There was nothing illegal in that. So now what Supreme Court will do? Now Supreme Court will issue the writ of Mandamus. Means Supreme Court will give the command to municipality to not to destroy the house of Bhadru. Okay, so it means that Mandamus means when court give order to any public officer or any public authority to do certain work or to not do certain work. For example, in the example of Bhadru, what Supreme Court did? Supreme Court actually ordered the municipality to not to destroy the house of Bhadru. Okay, so Mandamus means when Supreme Court means when court gives order to any government officer, to any government authority to do or to not do any work. So this was the meaning of Mandamus. Now friends, this writ can be issued to implement a public or a legal right and not a private right. Now what does it mean? So its simple meaning is that this writ can only be issued against government agencies. Okay, means this writ can only be issued against government and government agencies, government organs. Means this writ can only be issued against public organs, public agencies, public authorities, and this cannot be issued against any private individual or any private organization. So what is the meaning? So it means that the writ of Mandamus cannot be issued against any private individual or any private organization. This writ can only be issued against any public authority or any public organization. For example, any government agency. Okay. Now friends, Mandamus cannot be issued against an authority which is putting to use its discretionary powers. Now what does it mean? It means that court cannot issue Mandamus against any officer or any authority who uses his discretionary powers. Now what does it mean? So friends, here the work of government agencies can be divided into two parts. For example, the first part is when any government officer is taking orders from his higher officer and he is not taking decisions on his own. Means he is not using his mind to do that work. He is not taking his decisions on his own. Means he is not using his discretion. Okay, so discretion means when any officer uses his mind, he takes his decision on his own. Okay, so the first category of works are those in which any government officer does not uses his discretion. Means he does not takes the decision. He does not take the decision. Okay, he receives the orders from his higher officer and according to the orders and directions of the higher officer, he does the work. Okay. Now what is the second category? So second category is where any government officer takes decisions himself. Okay, means he takes decision whether to do that work or whether not to do that work. Okay, what should be done, how this work should be done. Okay, means he is using his mind to do that work. Okay, so he is taking his decisions himself, he is using his mind to do that work, means he is using his discretionary powers. So when any authority is using his discretionary powers, so against that authority the writ of mandamus cannot be issued. So this was the meaning of this statement. Now friends, this writ can't be issued against president or governor. Okay, so this writ cannot be issued against president or governor. So let's move further. So friends, then comes prohibition. So what is prohibition? So this writ can be issued only against a judicial or a quasi-judicial body. Now what is a judicial body? So judicial body means a court. Okay, so means this writ. Okay, so what are judicial bodies? For example, court is a judicial body, tribunals are judicial body. Okay, so this writ can only be issued against judicial or any quasi-judicial body. Now friends, this writ is issued to ensure that these bodies remain within their jurisdiction. Okay, so why this writ is issued? So this writ is issued to ensure that these bodies remain within their jurisdiction. Means if such a body takes up a case in excess of its jurisdiction, then the writ of prohibition is issued, which prevents the body from proceeding with the case. Okay, so if such a body takes up a case in excess of its jurisdiction, then the writ of prohibition is issued, which prevents the body from proceeding with the case. Okay, now what does it mean? It means that if any judicial or quasi-judicial body takes a case and that case is outside the scope of that body, means that case is outside the jurisdiction of that body, means that body does not have the power to decide that case. Okay, so if any judicial body or quasi-judicial body takes a case and that case is not under the authority of that body, that case is outside the jurisdiction of that body, so in that case Supreme Court or High Court can issue the writ of prohibition, and by issuing the writ of prohibition, what they do, they actually prevent these bodies from proceeding with the case. Means they stop these bodies from proceeding with the case, and then they orders these bodies to transfer this case to High Court or Supreme Court. Now friends, I know that this is little bit technical, so I will give you one example so that you can understand it very clearly. So friends, we all know that subordinate court is also a judicial body. Okay, and we all know that what is a subordinate court. So friends, suppose there is a subordinate court and a subordinate court took a case. Okay, and that case included the interpretation of the constitution. Okay, so what happened, that there was a subordinate court and that subordinate court took a case and that case included the interpretation of the constitution. Now what is the meaning of the interpretation of the constitution? So interpretation of the constitution means to find out the deep meaning from the articles of the constitution. Okay, means to interpret the articles of constitution, to find out the deep meaning by analyzing the provisions of the constitution, articles of the constitution. Now friends, as we all know that Supreme Court is the interpreter of the constitution, means Supreme Court has the power to interpret the articles of the constitution. Any subordinate court does not have the power to interpret the constitution. Means actually this case was outside the jurisdiction of that subordinate court. Okay, means that case was actually outside the scope of that subordinate court, means that subordinate court didn't have the power to take that case. Okay, so it was in excess of its jurisdiction, it was out of its jurisdiction. Okay, now suppose friends that case was in proceeding, means subordinate court took that case and that case was proceeding. Okay, so now what Supreme Court can do? So now Supreme Court can issue the writ of prohibition, and by issuing the writ of prohibition, Supreme Court will give order to that subordinate court that now you have to stop with this case. Means now you have to stop yourself from proceeding with this case. So what Supreme Court will do? Supreme Court will give order to the subordinate court, and Supreme Court will force the subordinate court to stop with the proceeding of the case. Means now that subordinate court will stop proceeding with the case, and then Supreme Court will give order to that subordinate court to transfer this case to the Supreme Court. Okay, so now Supreme Court will take this case and then Supreme Court will proceed with this case, then Supreme Court will give judgment for this case. Okay, so prohibition means if any court, any judicial body, any quasi-judicial body has taken a case and that case is outside the jurisdiction of that body. Okay, for example, what happened in this example, that subordinate court took a case and that case actually involved the interpretation of the constitution, but subordinate court do not have the power of the interpretation of the constitution. So actually this case was the outside of the jurisdiction of subordinate court. Okay, so definitely what Supreme Court will do in this case, Supreme Court will issue the writ of prohibition and Supreme Court will stop the subordinate court to proceed with the case, and then Supreme Court will give order to that subordinate court to transfer this case to the Supreme Court, and then definitely Supreme Court will give decision on this case. So this was the meaning of prohibition. So friends, let's move to another writ. So then comes certiorari. So what is the meaning of certiorari? So friends, it is very similar to prohibition. Okay, means this writ is very similar to prohibition, but there is one difference. So what is that difference? So it is issued to quash means to kill or to nullify a judgment, direction or order issued by a judicial or quasi-judicial body in excess of its jurisdiction. Now what does it mean? So again I will give you one example so that you can understand it more clearly. So friends, when I was explaining you the writ of prohibition, then I gave you the example of a subordinate court, and what that subordinate court actually did, that it took a case which included the interpretation of the constitution, and we all know that interpretation of the constitution is not the power of subordinate court. Means subordinate court do not have the power to interpret the constitution, means it is outside its jurisdiction. So what happened in the case of prohibition, that actually the case was going on, okay, the proceedings were going on, but judgment didn't came. Okay, means what happened, that proceedings were going on, case was going on, means case was not decided. Okay, judgment was yet to come, case was not decided. Means in the case of prohibition, court didn't give the judgment. Okay, so judgment was awaited, judgment was not come. But friends, so what Supreme Court did in that case? So Supreme Court actually stopped the subordinate court to proceed with the case, and Supreme Court ordered the subordinate court to transfer the case to Supreme Court. Now friends, imagine another situation, that what happened, that there is a subordinate court, and that subordinate court took a case which included the interpretation of the constitution, and again we know that interpretation of the constitution is actually outside the jurisdiction of subordinate court. Okay, and now what happened, that court was decided, means the case was decided, means the case was decided. Okay, means that subordinate court had already passed the judgment, subordinate court had already given the judgment. Okay, so now in second condition what happened, that the case was already decided, the subordinate court had already given the judgment. Okay, so now case was ended. Okay, subordinate court had already given the judgment. Okay, so now in that case what Supreme Court will do, so in that case Supreme Court will actually quash the judgment of that subordinate court. Means Supreme Court will declare that this subordinate court actually doesn't have the power to interpret the constitution. So this case was outside the jurisdiction of the subordinate court. So I am declaring the judgment of this subordinate court as null and void. Means Supreme Court will kill the judgment of subordinate court. Supreme Court will declare the judgment of subordinate court as null and void. Okay, and then what Supreme Court will do? Supreme Court will take over this case, and after that proceedings will go on in Supreme Court regarding that case, and finally then Supreme Court will give judgment on this case. Okay, so what happens in prohibition? That case is still going on, and Supreme Court actually stops the subordinate court or any judicial or quasi-judicial body from proceeding with the case. But what happens in certiorari? That if the case has already been decided, means if that judicial or quasi-judicial body has already passed the judgment, okay, so then what Supreme Court does? That Supreme Court actually declares that judgment as null and void, and then Supreme Court Supreme Court takes that case with itself, and then Supreme Court gives its decision on that case. Okay, so then finally who will give decision on that case? So Supreme Court will give decision on that case. Why? Because actually Supreme Court has the power to interpret the constitution. So this was the meaning of certiorari. So let's move further. So friends, then comes Quo Warranto. So what is the meaning of Quo Warranto? What is the meaning of this writ? So it literally means what is your authority? What is your qualification? Okay, so it means what is your authority or what is your qualification. Now friends, what is the purpose of issuing this writ? So the purpose of this writ is to ensure that a person holding a public office is competent or qualified to that office or not. Okay, so what is the very purpose behind issuing this writ? So the very purpose behind issuing this writ is to ensure that whether a person holding a public office is competent or qualified enough to hold that office or not. Now what does it mean? So I will give you one example so that you can understand this concept more clearly. So friends, suppose there is a person, okay, and that person is holding a office under the government, okay, or in other words we can say that that person is a government officer. Okay, so there is a person and that person is holding a office under the government, means we can say that that person is a government officer. Now friends, we all know that for any post under the government there is some certain minimum qualification, okay, or there are certain minimum qualifications which a person has to meet to get qualified for that post. Okay, now friends, suppose if somebody has filed a complaint in the court that this particular person who is a government officer, means he is holding an office under the government, this person is not qualified enough, this person does not have enough qualifications to hold that office. So now what court will do? So now court will examine that whether this person has enough qualifications to hold that office or not, whether this person is qualified enough to hold that post or not. Okay, so now what court will do? Court will analyze, court will review that whether this person is qualified enough, whether this person is competent enough to hold that public post or not. And if this person is not competent enough, if this person is not qualified enough to hold that government job, then what court will do? Court will simply remove him from that post. Okay, so then court will issue the writ of Quo Warranto. Quo Warranto means what is your qualification, what is your authority, how you can hold that government office. Okay, so Quo Warranto means that it is issued to ensure that a person holding a public office, means person holding a government job, is qualified enough to hold that job or not. So this is the meaning of Quo Warranto. So friends, let's move further. So then comes Article 32 and Article 226. So friends, here actually we will compare the writ jurisdiction of Supreme Court under Article 32 and writ jurisdiction of High Court under Article 226. So in the last class, I told you that Article 32 provides Supreme Court the power to issue writ, okay, and Article 226 is the writ jurisdiction of High Court, means Article 226 provides High Courts the power to issue writ. So in this slide, we will try to compare the writ jurisdiction of Supreme Court under Article 32 and the writ jurisdiction of High Court under Article 226. So friends, let's move further. So under Article 32, Supreme Court can issue writ only for the enforcement of fundamental rights and not for other legal rights. Now what does it mean? It means that suppose if the fundamental right of any person is violated, okay, and that person approached Supreme Court. So Supreme Court can definitely issue the writ for the enforcement of the fundamental right of that person. But now suppose second condition, that now the ordinary legal right of a person is violated. So first of all, that person cannot directly approach to Supreme Court. Why? Because we can only directly approach to Supreme Court on the violation of fundamental right. We cannot directly approach to Supreme Court on the violation of ordinary legal right. Ordinary legal right means rights which are provided by the ordinary law of the land, means the law which is made by parliament or any state legislature. So if our ordinary legal right is violated, so the first thing is that we cannot directly approach to Supreme Court. And the second thing is that Supreme Court do not have the power to issue writ for ordinary legal right. Okay, so the first thing is that Supreme Court can only issue writ for the enforcement of fundamental right. Means if the fundamental right of a person is violated, then Supreme Court can issue writ. But if the ordinary legal right of a person is violated, then Supreme Court cannot issue writ. But friends, what happens in the case of High Court? So under Article 2 to 6, what happens that High Courts can issue writ not only for the enforcement of fundamental rights, but also for the enforcement of other legal rights. So what does it mean? So it means that if the fundamental right of any person is violated, then High Court has the power to issue writ, and by issuing the writ, High Court can enforce the fundamental right. High Court can ensure the enforcement of the fundamental right of that person. But friends, if any ordinary legal right of a person is violated, then also High Court has the power to issue writ and to restore the ordinary legal right of that person. So what is the first difference? So the first difference is Supreme Court only has the power to issue writ under fundamental rights. Supreme Court do not have the power to issue writ for the enforcement of ordinary legal rights. But High Courts have the power to issue writ for the enforcement of ordinary legal rights. So here High Court has more power. Okay, why? Because High Court can also issue writ for the enforcement of ordinary legal right, but Supreme Court does not have this power. Now friends, Constitution places now let's see the second difference. So Constitution places a duty on Supreme Court to enforce fundamental right if found violated. Now what does it mean? So suppose if the fundamental right of any person is violated, and that person approached Supreme Court for the relief. Now friends, Supreme Court is duty bound to ensure the enforcement of the fundamental right of that person. Supreme Court is duty bound to give relief to that person. Okay, means it is the constitutional duty of Supreme Court to enforce the fundamental right if the fundamental right of any person is violated. What does it mean? It means that Supreme Court cannot suggest you any other remedy, any other way to restore a fundamental right. But Supreme Court has to get your fundamental right restored. It is the duty of the Supreme Court to get your fundamental right restored, to restore your fundamental right. But friends, there is no such constitutional duty in High Court to implement the fundamental rights. What does it mean? So suppose if the fundamental right of any person is violated, and that person, instead of Supreme Court, he approached High Court. But friends, High Court do not have any duty. Okay, there is no constitutional duty of High Court to implement the fundamental right. Means if High Court wants, then High Court may implement the fundamental right of that person. And if High Court doesn't want, High Court may not implement the fundamental right of that person. It is up to the choice of High Court. So if High Court doesn't want to implement the fundamental right of the person himself, then High Court can suggest any other remedy. Okay, so what does it mean? So it means that instead of implementing the fundamental right of the person himself, High Court can suggest any other method or any other remedy to give relief to that person, to get the fundamental right of that person implemented. Okay, but Supreme Court is duty bound to implement the fundamental right of the person, to enforce the fundamental right of the person. But there is no such constitutional duty on High Court. If High Court doesn't want, High Court may not implement the fundamental right of the person. High Court may suggest any other method, any other remedy to the person for enforcing his fundamental right. Now what is the third difference? So the third difference is that jurisdiction of Supreme Court under Article 32 extend over whole of India. But jurisdiction of High Court under Article 226 is territorial limited. Now what does it mean? So it means that definitely we all know that Supreme Court is for entire India. So Supreme Court can take cases from entire India, and definitely Supreme Court can pass judgment for entire India. But the jurisdiction of High Court is territorially limited. For example, the jurisdiction of Jabalpur High Court is Madhya Pradesh state only. Okay, so what is the jurisdiction of Jabalpur High Court? It is Madhya Pradesh state only. Okay, so means the jurisdiction of High Court is territorially limited. It is not for entire India. It is for the related state. It is territorially limited. Now friends, initially High Courts didn't have the power to issue writ for the enforcement of fundamental right. Okay, High Courts got that power after 44th Constitutional Amendment Act. So after 44th Constitutional Amendment Act, High Courts also got the power to issue writ for the enforcement of fundamental rights. Okay, so friends, let's move further. So then comes judicial review. So in this class we will discuss about judicial review in detail. So friends, what is the meaning of judicial review? So judicial review means the power of Supreme Court and High Courts to declare an action of executive or legislature to be unconstitutional or void if the actions violate one or more provisions of the Constitution. Now what does it mean? So friends, suppose if police or the executive branch of the government has done anything which is unconstitutional, means which is not according to the provisions of the Constitution, then Supreme Court or High Court can review that action of police or executive, and Supreme Court and High Court can declare that action invalid and unconstitutional and void. Similarly, suppose if Parliament passed any law and if that law is not consistent with the provisions of the Constitution, means that law is violating one or more provision of the Constitution, then Supreme Court can declare that law as invalid and void. Okay, so then Supreme Court has the power and High Courts have the power to declare that law unconstitutional and void. Okay, for example friends, NJAC. So what was NJAC? So NJAC was National Judicial Appointment Commission, and through National Judicial Appointment Commission, actually Parliament wanted to control the appointment of judges. And by controlling the appointment of judges, they actually wanted to dilute the independence of judiciary. Okay, and definitely independence of judiciary cannot be diluted. Okay, and friends, independence of judiciary is the part of basic structure. Okay, so Parliament actually does not have the power to dilute the independence of judiciary. Why? Because it is the part of the basic structure of the Constitution. So what Supreme Court did? So Supreme Court actually reviewed the action of Parliament, means reviewed that law, and after reviewing that law, Supreme Court, on the grounds that it is violating the independence of judiciary, Supreme Court declared NJAC as null and void. Similarly friends, in the previous classes I taught you about the section 66 capital A of Information Technology Act in detail. So this provision was also giving arbitrary power to the state, arbitrary power to the police. Okay, so this provision was also declared unconstitutional and void by the Supreme Court of India. Now friends, judicial review was mostly implicitly provided in the Constitution. Now what does it mean? It means that the power of judicial review is not directly written in the Constitution. It is provided by the Constitution indirectly through many provisions. For example, courts can do judicial review by the power of court under Article 32 and Article 226. Okay, for example, Supreme Court has the power of judicial review under Article 32. For example friends, Supreme Court has the power of writ jurisdiction under Article 32, and High Courts have the power of writ jurisdiction under Article 226. And in yesterday's class also I explained you that for issuing writ, first of all, Supreme Court and High Courts have to review the action of legislature or executive, and after reviewing the action, that whether the action is correct or not, whether the action is constitutionally valid or not, then what Supreme Court or High Court will do, then they will issue the writ. Okay, so for issuing the writ, they need to do judicial review. Okay, so courts have writ jurisdiction means Article 32 and Article 226 also indirectly provides the power of judicial review to Supreme Court and High Court respectively. Now friends, however, the Article 13 explicitly confers the power of judicial review on the court. Now what does it mean? It means that Article 13 directly provides the power of judicial review to the Supreme Court. Okay. Why? Because what was Article 13? So according to Article 13, any pre-constitutional law or any post-constitutional law, if it violates one or more fundamental right, then that law will be declared invalid and void till the level of inconsistency. Okay. So if any pre-constitutional or post-constitutional law violates one or more fundamental right, then that law will be declared invalid and void. And before declaring that law invalid and void, first of all, Supreme Court has to check that whether the law is inconsistent or not. Okay, whether the law is violating fundamental right or not, means Supreme Court has to do the judicial review. So Article 13 directly provides the power of judicial review to the Supreme Court, okay, to the court. Now friends, the power of judicial review can also be seen implicitly in the concepts of. Now what does it mean? It means that these concepts also indirectly provides the power of judicial review to the Supreme Court and High Court. For example, the doctrine of limited government. Now what does it mean? So limited government means when the powers of the government are not unlimited or arbitrary. The powers of government are limited. Government works as per the rules of constitution, as per the provisions of constitution. Now how this doctrine provides the power of judicial review to the court. So friends, suppose if government tries to do something which is unconstitutional, okay, means if government wants to become unlimited, government want to become arbitrary, government wants to do anything which is arbitrary in nature, means in simple words, government want to do something which is arbitrary or unlimited. Okay, so in that case, first of all, what court will do? So first of if court has to ensure that government has to be limited, and to ensure that government has to be limited, so suppose if government has done anything and that action of government is arbitrary, okay, means that action of government is not according to law, it is not according to rules. Okay, it is not according to constitution. So now what court will do? Court will actually first of all review the action of government, will analyze the action of government, that whether this action of government is arbitrary or not. And if court will found that this action of government is arbitrary, then court will declare that action of government unconstitutional, invalid and void. Okay, so to ensure that the government is limited government, court has to be given the power of judicial review. Okay, and by using the power of judicial review, court can ensure a limited government in the country. So the doctrine of limited government also provides the power of judicial review to the court. Similarly, the doctrine of supremacy of constitution. Now how does this doctrine provides the power of judicial review to the court? So for example, if parliament has made any law which is violating suppose if parliament has made any law which is violating fundamental right, so which is violating fundamental right, which is not according to the provision of the constitution. So now first of all, what court will do? So first of all, court will review the action of the legislature, means court will review the law, that whether this law is violating fundamental right or not, okay, whether this law is violating the provision of constitution or not. Okay, and if court will found that this law has actually violated the fundamental right, or this law has violated the provision of the constitution, then what court will do? Court will declare that law unconstitutional, invalid and void. Okay, so what court will do? By using the power of judicial review, court will ensure the supremacy of constitution, means no one in the country tries to become more powerful than the constitution. Even the parliament and the government do not try to become more powerful than the constitution. Who is supreme? Constitution is supreme. Okay, means nobody tries to violate the provisions of the constitution. Similarly, friends, the doctrine of separation of power, rule of law and principle of checks and balances. These all principles and many other principles with them gives the power of judicial review to court indirectly. Okay, so these principles, and there are many other principles also which indirectly gives the power of judicial review to the court. Okay, means court has to get this power. Okay, so court needs this power. Court needs the power of judicial review to protect these doctrines. So these all doctrines, these all principles gives the power of judicial review to court indirectly. Now friends, judicial review is applied by the court after the act has been committed. Now what does it mean? It means that suppose if Parliament is making any law, now Supreme Court knows that this law is unconstitutional, means this law will violate the constitution when this law will be made. So when the law is in making stage, at that stage Supreme Court will not apply judicial review and Supreme Court will not declare that law invalid. But once the making of the law is completed, means now the law has been completed, the law has been made. So now Supreme Court will do judicial review of that law, and if Supreme Court finds that this law actually violates the constitution, then Supreme Court will declare that law invalid. Okay, for example, what happened friends, when Parliament was making NJAC, National Judicial Appointment Commission, at that point of time one person filed a public interest litigation PIL in the Supreme Court, and he said that Parliament actually wants to dilute the independence of judiciary. Okay, so Parliament wants to dilute the independence of judiciary, so this is unconstitutional. So please sir, declare this law unconstitutional, declare this law invalid. But what Supreme Court said, that actually now also they are making this law, the law has not been completed, so let them complete the law first, and after the law has been completed then come to us. Okay, and then we will declare that law invalid and void. Okay, so means when the act has already been committed, then Supreme Court applies, then court applies the principle of judicial review. Now friends, ordinarily courts apply judicial review on the basis of petition filed. Now what does it mean? It means that court does not apply judicial review suo moto. Suo moto means on their own. So court does not apply judicial review on their own in ordinary circumstances. So what happens in ordinary circumstances or general circumstances, that if a person files a petition in the court, then what court does? Court applies judicial review, and then court declares that action of executive or legislature invalid and void if it violates the constitution. Okay. Now friends, what are the advantages or benefits of judicial review? So the first advantage is that judicial review has helped the judiciary to protect itself from the possible encroachment on its powers by executive and legislature, which is essential for the judiciary to maintain its neutrality. Now what does it mean? So it means that if executive wing of the government or legislature tries to encroach on the powers of judiciary, means if they try to decrease the powers of judiciary or to take away the powers of judiciary from it, then judiciary can use this weapon. Judiciary can use judicial review and judiciary can protect itself. Okay. For example, friends, what happened in NJAC, National Judicial Appointment Commission, that Parliament actually wanted to control the appointment of judges. And by controlling the appointment of judges, they can actually dilute the independence of judiciary. Okay, and definitely they will also be able to interfere in the neutrality of the judiciary. Okay, so by controlling the appointment of judges, they actually wanted to dilute the independence of judiciary and to dilute the neutrality of judiciary. But what Supreme Court did, Supreme Court actually applied the judicial review, and by applying the judicial review, Supreme Court has reviewed that law, and then Supreme Court said that this law tries to dilute the independence of judiciary, and independence of judiciary is a part of basic structure of the constitution. So Parliament doesn't have the power to do so. Okay, so Supreme Court declared NJAC as null and void. So by applying the principle of judicial review, Supreme Court can actually protect the judiciary from the encroachment of executive and legislature. Now friends, judicial review also helps the court to ensure supremacy of constitution, balance of power among the three organs of the state, separation of power, rule of law, fundamental rights, etc. Now what does it mean? It means that by using the by using judicial review, Supreme Court actually ensures the supremacy of constitution, balance of power among the three organs of the state, separation of power, rule of law, fundamental rights, etc. Now what does it mean? So suppose friends, if the legislature, means if parliament makes any law and that law is not consistent with the provisions of the constitution, means if that law wants to violate the provisions of the constitution, then what Supreme Court can do? Then Supreme Court can actually do judicial review, and then after doing the review of the law, if Supreme Court finds that that law actually wants to violate the constitution, that law is violating the constitution, then Supreme Court can declare that law invalid and void. Means by using judicial review, Supreme Court can ensure that constitution is supreme. There is supremacy of constitution in the India. Even parliament and the government of India is not greater than the constitution. Who is supreme? Constitution is supreme. There is the rule of constitution in India. Okay. So by applying the principle of judicial review, Supreme Court actually ensures the supremacy of constitution. Similarly, Supreme Court also ensures the balance of power among the three organs of government, separation of power, rule of law. Okay, means Supreme Court sees whether the rule of law is correctly maintained or not. Okay, fundamental rights are correctly ensured or not. For example, if the parliament made any law and that law violates any fundamental right, okay, so what Supreme Court will do? Supreme Court will judicial review of that law, and when Supreme Court will analyze that law, means when Supreme Court will review that law, if Supreme Court finds that actually this law is violating the fundamental right, then Supreme Court will simply declare that law invalid, okay, and the law will become dead. Okay, so judicial review is just like a Brahmastra. Okay, so judicial review is just like a Brahmastra in the hand of judiciary, in the hand of Supreme Court, in the hand of High Court. Okay, that if executive or legislature tries to encroach on the powers of judiciary, if legislature or executive wants to dilute the supremacy of constitution, balance of power, separation of power, rule of law, fundamental right, or anything, then what judiciary will do? Judiciary will use that Brahmastra. Means judiciary will use the weapon of judicial review, and by doing judicial review, what judiciary will do? Judiciary will ensure the maintenance of the supremacy of constitution, balance of power, separation of power, rule of law, fundamental right, and more things like that. Okay, so judicial review is very, very important. Okay, why? Because judicial review is just like a Brahmastra in the hands of judiciary. Now friends, in Minerva Mill case 1980, Supreme Court declared that judicial review is a part of basic structure. Now what does it mean? It means that Parliament doesn't have the power to remove judicial review from the constitution. It is the part of basic structure. Means even by the constitutional amendment, Parliament cannot remove judicial review from the constitution. It is the part of basic structure. It is the basic nature of Indian constitution. Friends, in the last class, I gave you one assignment, but till now, only few students gave the answer. So I am giving you the time of one more day. So please take your time and try to give the answer. And even if you don't know answer, then also actually try to give the answer. Okay, so even if you don't know answer, then also don't hesitate to answer. At least try to give the answer. So now I will announce the winner and I will explain you that concept in the next class. Okay, so that's all for today. So friends, I hope that you all have enjoyed the lecture, and if you have enjoyed the lecture, so please like the video, comment, subscribe to my channel, press the bell icon, share this channel to as many people as you know, and share this channel. Okay, and till then, take care of yourself. Thank you.